low where Hancock Run feeds into Nanchemoy Creek. Have you ever seen that bridge and that road flood?
Yes, very deeply. It becomes a river. I know when a large rain event is expected, depending on the time of day, I will either stay home from work or come home early so that I'm not cut off from getting home by the flooding.
And just to make sure we're clear on the location, only because we've had such a lengthy tangent here, we're talking about a bridge that crosses Route 6.
Correct.
At Nanchemoy Creek, I'm sorry. Route 6 at Nanchemoy Creek. Thank you.
And all of this would be downstream from the subject property. Is that correct?
Yes.
And downstream meaning the runoff from the subject property would go into Hancock Run, which would then go into Nanchemoy Creek, which then goes in normal conditions under the bridge on Maryland Route 6.
Correct.
Okay. How often would you say that you have witnessed flooding and road closing events at the bridge at the bottom of the hill at Grayton?
I can just place an objection on the record. I thought you just sustained his objection and said we're not going to talk about what's happening on Route 6, 301, or Route 6 bridge and what effect it might have. It has nothing to do with Adams-Willett Road, the width of it, or the drainage on Adams-Willett Road. It has to do with downstream of Ms. Redding would probably know, the tremendous watershed that goes through that, underneath that bridge, which is more than this 103-acre project.
My understanding of the objection was specifically about evidence related to erosion and soil erosion, because that was not brought up on appeal.
And I object to the relevance of why we're talking about Route 6 bridge, a state highway.
Mr.
We're talking about flooding of roads, which was all mentioned in the appeal. We are talking about flooding of roads that is related to this property.
At what point do you cut it off, Mr. Chairperson? Is the flooding of Chapel Point Road an issue here? Is the flooding of Madeline Road and Penns Hill an issue here? We're talking about a development specifically coming off of Adams-Willett Road.
Got it.
May I be heard briefly in response to
the
argument of counsel? The role of the zoning officer and the county staff in reviewing a subdivision application, and the role of the planning commission in deciding whether to approve a subdivision application, and this board's role on appeal in connection with the issues of error that are raised doesn't relate to whether everybody feels good about this subdivision, whether they think it's a good thing or a bad thing, whether the public interest really ought to be served by this. They're not the issues that are before the staff, the planning commission, or this board. A subdivision applicant is entitled to the approval of its application, and our staff is duty-bound to approve that application if it satisfies the regulations that apply to its approval. And when the staff goes through, they go through and they analyze the regulations and whether the subdivision application is in compliance with those regulations. If council wants to raise some issue about flooding on Route 6, it has to be, this is not whether it's raised in the petition or not. This is whether it's relevant to the approval of this subdivision application pursuant to the regulations. Council has been very specific in connection with the issues that they actually raised. They argued under Section 75C that the applicant should have been required to widen Adams-Willett Road. They argued that under the county's adequate public facilities ordinance, the capacity of the road was not is not sufficient for the development proposed. They are specific regulations, and there's a claim of error, and this board can decide it de novo. But just to throw out whether we feel good about this application and whether we like or don't like bikers on the road has nothing to do with this board's jurisdiction. And the staff is here to explain why, in connection with the issues raised, they believed that this application satisfied the regulations. They don't have an opinion as to whether they feel good about this road or bikes or flooding on Route 6, because it's not relevant to their responsibilities, and I would respectfully submit it's not relevant to this board's responsibilities. That's why we're seeking to limit this appeal to the issues presented so we can litigate them fairly. Thank you. I appreciate your
Mr. Fisher, I disagree with that, and we can talk about it, but I understand that the Planning Commission has strict rules like that. If they meet all the criteria, they have to approve it. But this board also can take more things into consideration than the Planning Commission can. They can take the welfare of the community into consideration. That's in our rules. So although the Planning Commission is limited and they can't refuse to allow something if everything's been permitted, we have a wider scope to look at.
Okay. Mr. Martin, I respectfully disagree with that, and I object to the board's interpretation of law in that respect and submit it's erroneous. This board sits as an appellate authority to review de novo the rulings of the Planning Commission, but this board's role is to determine whether this application is in compliance with law and regulations. This is not a special exception case. This board's role is not to determine whether it thinks this is a good or bad application or whether the public interest would or would not be served. This board's role is to determine de novo whether this applicant complied with law and regulation. So I respectfully disagree with and would object to the board's assertion of that jurisdiction.
I'll put our attorney on the spot.
Sure would like to be heard on that objection.
Go ahead.
I don't feel good about a proposal for an inadequate road that people have to ride bikes on and drive cars on at the same time. I don't feel good about Section 75C making complete sense that the applicant for the subdivision should have to expand the road when the road's inadequate, and yet that not being done and some other agreement being cut that was not even shown or discussed adequately, as you can see from our videos, with the Planning Commission. I don't feel good about the manner in which adequate public facilities are treated as an ugly stepsister to a determination as to whether an application for a subdivision is a good idea or not. Those are the things we don't feel good about. If you want the actual application of the law, then what we're referring to is adequate public facilities. Is there adequate roads here? Did anybody even bother to look to see where there was adequate roads? And I will get to the nut of this, and we had the same nut in the Guilford case that my colleague just raised. He indicated that the staff is obliged, when someone comes in and meets all the requirements, the staff is duty-bound to approve their application. The staff approves nothing. Nothing. The staff approves nothing. The staff recommends approval. And it recommends approval to a planning commission, and that's where the problem goes awry in this county. The staff approves nothing. They recommend approval to a planning commission who is either given enough facts or not given enough facts, either by the applicants or by the staff or by the people who are refused the ability to testify and put on their own evidence. That's the situation we find ourselves in here again. I am not raising anything about whether I feel good about this project. I'm raising issues about a road that's 16 feet wide that people need to share, where there's going to be, by the admission of the applicant in this thing, where there'll be 330 car trips a day added to a road that already is 16 feet wide by their admission. I'm always.
I'm going to interrupt you.
I'll give you a chance to speak after he's done.
He's testifying, and this is an argument. It's an attorney-client, ask a question, answer it, there's an objection, rule on it, but this is inappropriate. Unless he wants to let me testify, cross-examine him, he's testifying to matters that are not before this board. The only testimony for this board is John Mudd, Ms. Tominac, Mr. Moorhead, and what Ms. Redding has said. That's it.
Who testified about 16-foot wide roads.
Yes, that is my question.
And bicycles and flooding and more inadequate problems downstream on Hancock Run Road.
All right.
If I could make a suggestion,
Yes.
Mr. Chairperson, although a number of topics were discussed by the attorneys in their arguments about the objection, I believe the objection at the time it was made, Ms. Redding was testifying that there's flooding that occurs at an area beyond Adams-Willett Road. That's the only thing she was talking about.
Thank you.
I don't think she articulated whether or not she felt good about that or not, or had any kind of feeling about it. She was simply testifying that, in her opinion, flooding occurs now. Obviously, there has to be some kind of showing between this subdivision and flooding or what might come from that. But if one goes back to what was occurring at the time of the objection, I think it was simply her testifying about flooding as she perceives it in those areas.
Right.
Can I just ask a question? And I don't know if the question is for the Planning Commission or the lawyers. This first sentence here states that Adams-Willett Road does not meet the 22-foot wide regulation for a major subdivision.
What are you reading from?
I'm reading from the letter that Mr. Moorhead wrote. And it states that it is only 16 foot wide. Is the requirement for the road to be 22 feet?
I think that we ought to wait to ask that question until we have their witness in front of us. We had an opportunity. We did discuss this topic, I believe, in April at length, but I believe that same witness is back again, which would lead me to believe he will be on the stand.
But I'm just asking, is the requirement for the road, and I would think that the Planning Commission would know the answer to that. Would they not?
There's a gray area there that they were talking about at the first meeting. That's what we're going to have to figure out.
Right.
Would you like me to state the county staff's position?
Sure.
The subdivision regulations do not say thou shalt not approve a subdivision if it's not on a road that's 22 feet wide. The way it's structured is differently. The county's road ordinance states as a standard 22 feet for a rural road such as this. But the remedy in connection with subdivision applications is set forth in Section 75, which contains a dedication requirement in Section A that the applicant is required to dedicate sufficient right-of-way to permit the widening of the road. In Section B, the applicant is required to construct one half of the widening of the road on its property. And in subsection C, if it's feasible, the applicant is required to construct the road to the nearest conforming or standard road. In this situation, the issue before the board is that the staff concluded that it was not feasible for the applicant to construct the 22-foot road or to construct any additional pavement surface because there was insufficient right-of-way to construct and to provide the slopes and construct the drainage that would be necessary. So that's the issue before this board. Respectfully, ma'am, that it's not a situation where it's the subdivision regs say application shall be denied if it's not on a 22-foot road. It's unfortunately more complicated. 22 feet is the standard, but the remedy is set forth in detail in Section 75, A, B, and C, and I think we've stated the staff's position as to how they analyzed in each respect A, B, and C. Thank you.
That would be one of our decisions is if they can't do 22, then should we go ahead and approve it at the lesser amount?
Do we agree that staff's assessment that it's not feasible?
Well, not only that, but if it's not feasible and they're not going to change it, is a 15-foot wide road sufficient
16, yeah.
for the subdivision?
Yeah.
So I
Even
object to
though
that.
legally they're fulfilling their obligation, but again, we can expand a little bit beyond that and look if that road.
Well, let's get back on
I
target
object to
here.
that legal interpretation. I'm sorry, I have to make a record.
Yeah.
I object to that legal interpretation as erroneous.
Yeah.
Respectfully, sir.
All right, so let me get back to the original discussion here, which is, can we hear testimony about flooding of a road that the witness described as downstream from the subject property? And I think that as long as we stay very close to that discussion and it's tied back to the subject property with the streams as you've done, then we'll continue to hear it.
I hate to kick this one more time, but it's going to make a difference on our decision here. So I just ask our attorney to look it up while they're doing their testimony, and we are allowed wide discretion for the good of the community for variances and exceptions, things like that. And they're saying that since this is an appeal, we don't have that same latitude. And I want to know, do we or don't we?
You do not. When you look at the standard of review in appellate decisions, you have to decide whether the decision of the Planning Commission was arbitrary, capricious, contrary to law. That's the standard that you use in order to make your decision. So it's not whether the decision granting or denying, I guess, theoretically, granting the, in this case, major subdivision, was for the public good, or the decision was wrong because it was contrary to the public good. Your standard is simply, your standard review is, was the Planning Commission wrong in its decision? And again, the difference, though, on a de novo appeal is that you can hear evidence the Planning Commission never heard. And you can say, well, regardless of what they heard, we're hearing this, and because of that information on the issues articulated by the appellant, we're going to come to a different conclusion from the Planning Commission, and we're going to say that whatever the basis is, that it was wrong, and you can do that. But the criteria that you have with variances and special exceptions, obviously, if one were going to use a phrase like public good, there'd have to be a very specific articulation about what that would mean. But that's not applicable to administrative appeal.
In that case, Mr. Fisher, my apologies.
Well, I will point out that the Adequate Public Facilities Manual, Section 8, under Planning Commission consideration, does lay out the criteria that the Planning Commission should use when they determine that adequate public facilities exist. And it lays out in that Section 8 a two-part test. It says that the Planning Commission shall review, and therefore, by extension under Appeal Us, shall review the adequate public facilities study and other information submitted by the applicant to determine if the level of infrastructure exists or will exist to meet the standards of the zoning ordinance, and whether the approval of the proposed development is in the public interest. And that is explicitly within the purview of the Planning Commission and by extension us on appeal according to the Adequate Public Facilities
So we do
Manual.
have discretion.
I'm just reading it. I'm not interpreting it.
Well, it's something we're going to have to figure out for sure before we decide
Well,
this
we'll
thing.
get to that later. I think we ought to let this witness proceed, and I think as soon as this witness is done, we ought to take a quick break. So if Mr. Wolfgang